Live. This is Senate Health and Welfare, and we are taking testimony on H-171. We've had a little hiatus with a fire alarm, and now we're back. So I see that Joe Nussbaum, John Gordon, and Stuart Schur are all here. Are you going to testify together, or how are we doing this one?
We could pull this chair away and do it from here if that works.
Any way you would like. I mean, you could have one sit in the middle and two chairs pull up. It might be more comfortable. Yeah, do that.
Yeah, we were planning to talk about different portions.
Oh, well, that's okay. Well, no, go right ahead. You do it where you were gonna.
I'll jump in the middle and you guys can, since I'm starting.
And you know our time constraints, unfortunately, it's just really.
We'll keep it moving.
Yeah, I think if we can get the essence of your testimony, and then we'll have your written testimony, that would be great.
All right, just jump in.
Sure, and Senator Gulick, Senator Weeks, Senator Williams, Senator Lyons, Senator Hardy will be in a minute.
Wonderful. Well, I'm Joe Nussbaum. I'm the director of Dale's Division of Licensing and Protection, which is the division that has the Adult Protective Services component within it. I have been with the division for going on 8 years now, and in those 8 years, one of the key things, and what I'll primarily be talking about today, is the vulnerable adult definition as it exists in statute. It's sort of caused endless confusion to our scope of operations. And so that was one of the big drivers, one of two big drivers with this bill when we've been working pretty diligently for the last several years on updated bill language. And this was one of, I would say, the two key areas. The other key area is the evidentiary standards, which thankfully that has been fixed in the bill as it passed the House. But the House did pass. Basically what we're concerned about is the same language at the end of it, which has caused confusion. So there is a memo, as Senator Lyons pointed out. I won't go through that point to point, but I would urge everyone to look at it. I think there's a lot of
We have it, but we do. It's under Dale. So if it's under the Department of Aging and Defense.
So, I will say without exaggeration, we've spent hundreds of hours discussing this definition, and I will just sort of talk about the crux of what the issue is that causes all this confusion. And it's the very last point. It was an add-in in one of the recent revisions a few years ago to the definition of vulnerable adult that has a clause at the very end that adds on some impairment of the adult's ability to protect the adult from abuse, neglect, or exploitation. And I appreciate that the intent of this was to create sort of a catch-all for all the ways that an adult can be vulnerable that wasn't specified in the definition leading up to that. The whole definition leading up calls out very specific things that would put you in the vulnerable category. And then you've got sort of this broad category, broad catch-all. The problem is, especially for adult protective services trying to define its operations, it doesn't make clear to the division who would not be a vulnerable adult. When you say having a diminished ability to any kind of hypothetical maltreatment as defined in statute, it's very hard to think of any adult that doesn't have some diminished capacity to some form of vulnerability. And I can use myself as an example. I wear glasses. I very much need to wear glasses. If I was the victim of a physical assault and the person recognized that and knocked off my glasses knowing I would have a diminished ability, that could be reported to Adult Protective Services. Adult Protective Services under the statute would open that for investigation because I did have a diminished capacity to protect myself from that abuse. However, it's APS and it's the department's feeling that doesn't make everybody with glasses a vulnerable adult, nor should it. And the memo goes into other examples, experiencing depression, even being short of stature. You can think of linkages where those circumstances would make you vulnerable and may make you subject to an APS investigation, but it's too broad to be practically applied to the scope of operation. So I'll refer to, when this bill was introduced, as I said, Dale worked on new language for several years, and it did try to provide a correction by adding the word "the" to make a linkage to the maltreatment being reported and the vulnerability. It was removed, reverting back to the existing definition. Legislative council pointed out, and I agree with it, that just having the word "the" doesn't go far enough to clarify whether that linkage should be there or not. It should really be called out one way or another. You're either having a broad catch-all where everybody could potentially be vulnerable, or you're saying that there is a linkage between what's being reported and the vulnerability status. So the department, and looking at any legal findings on this, and there's not a lot, and it's a little unclear because whether they're holdings or not, they have found that, and that's what's in the memo, that there should be a linkage between those two things. So that is how we currently operate. We do think that I do agree with legislative council that it should be clarified more explicitly one way or another. So there is suggested language on that. I'll just make a couple of other quick points on this that I think are relevant. All the other states, one of the arguments that was put forth was that no other state has this linkage. But I think that's a little misleading because no other state has this broad catch-all at the end of its vulnerability definition that we know of. I haven't read every state statute, but our neighboring states, the banner states that have the good models that we modeled this after to try to update statute, don't have that. So it does seem in line with what the practices are here. I will also say, I don't know if it's a concern of this committee about whether this is a budget neutral bill or not, but everything the department did was very carefully constructed to keep this budget neutral, so that we would take the resources we have and apply them in a way that better serves vulnerable adults. If this is made explicitly broader, this would not be budget neutral. We currently screen out about 75% of the reports that come to APS, and a significant portion of that is from the adult not being vulnerable. So if there, say, needs to be an assessment of every report that comes in to look for the vulnerability, or because there's a hypothetical way that that linkage could be made, it will greatly increase the scope of APS operations.
Okay.
So that's, and as succinct as the way I could talk about vulnerability, like I said, we talked about it all day, but if you have questions about that or any other part.
No, that's fine. So you've got 3 separate recommendations in the memo.
Yeah, and so my colleague John Gordon will talk about the other 2.
Okay.
Before I hand the seat over to him, I did take note in the walkthrough last week, you asked if there were issues of concern to bring up. And so I could proactively talk about, I know that it has been discussed about the definitions of abuse and neglect, and whether what is called a mens rea or an intent level of negligently versus a reckless intent. I will just say that, again, this is one of the 2 big areas that needed to be fixed, was we have a reckless standard that was put in statute. This is not typical for every state that we know of. They either the vast majority of them have a strict liability level, so they don't look at intent at all. They just look at the effect. The ones that have intent do may mention negligent, and that's what we did it. We thought that negligent was it is the compromise. It is the ground between strict liability and having some level of intent, so that if there is a mistake made versus professional negligence, it gives APS the ability to sort of apply a reasonable person standard and say, this doesn't rise to the level. But it is absolutely critical for what APS is, what this whole statute is set up to do, to look at these instances of potential abuse and neglect, and to protect vulnerable adults from actions that put them at risk. And I can give one example that I think is just a classic example that illustrates it. We've had several cases that have resulted in injury or even death, but one where there was a ventilator technician that forgot to turn the ventilator back on that they were cleaning, that somebody relied upon, and they died as a result. APS is not concerned with the professional standards of that profession, or any other board that might look at, a regulation board. It's looking at protecting vulnerable adults and saying, was there an expectation, a dependency on that caregiver that was not followed? And that's what I was concerned with. Because we don't have a negligent level, it was reckless. That case was not substantiated because the person was simply able to say, I forgot to turn it on. So we need to move past this ability for perpetrators to say, I forgot, and have that get them off the hook. So it's, again, we're not concerned with professional standards where we look at it, if there's a plan of care or something that prescribes what needs to happen. This is, again, all of our neighboring states have this strict liability level. It is very much in line. It was a big thing that we were looking to fix with this. So it's, this may come up more and my colleagues may speak more to it, but from my perspective, that was just, I thought it was important, it was worth addressing.
And thank you. Thanks for addressing that.
Anything else for me
Any other
or?
questions? We're on a fast track.
Yep, I understand. I'll hand it over to John Gordon.
Yeah, we're really on a fast track. Go ahead. And I'm just going to say for the folks who are waiting to testify, we'll try and get through this one, but then unfortunately, we're going to have to hold off with others today. We'll put it back on our calendar. Go ahead.
John Gordon, Director of Adult Protective Services Program. This is going to speak to the other two items from the memo, the caregiver definition, and then an addition regarding perpetrator interviews. So I'll speak from the intent of the department when we develop the language. The definition of caregiver is used in several other places in the statute. It relates to the definition of neglect. It has several implications for our process. What we believe occurred with this is when we wrote the definition of caregiver as it was formatted to the bill as introduced, the definition was inadvertently changed and that change was carried through. But our concern with the language as it stands is we believe the language that stands currently, anyone who provided care for an individual that was needed by that individual would be considered a caregiver. And we think that this is overly broad. So for instance, if I'm an individual in need of care who lives in a household who happens to share the household with a family member who is not otherwise obligated to provide care, not signatory to a treatment plan, not in agreement with the treatment plan, if they were to, in passing, do something for me, they would now be considered a caregiver and be subject to requirements of a caregiver and subject to definitions and neglect under this. We believe that the definition of a caregiver should be restricted to those individuals who know that that's what they are. Like, yes, I agree to this. I affirm to this. I'm on a treatment plan. It doesn't have to be necessarily a formal document, but they have to be able to make some statement some way. I'm a caregiver. Yes, I will do this thing for this person. And so we believe that that should be updated in that way. The other point I want to speak to is in the section 6906 regarding perpetrator interviews. This is in C3, page 25. Part of the required elements of an investigation is that we interview the alleged perpetrator or offer an interview to the alleged perpetrator. They can decline. They could decline by not responding. However, directly after the section that speaks to the requirements for the investigation, where it starts to talk about the outcomes of the investigation and the report that was written from that investigation, it again says, prior to substantiation, the department shall interview the alleged perpetrator unless the alleged perpetrator declines. We believe this language to be redundant and also would possibly allow the perpetrator to hold up an investigation simply by not responding. So we believe that this language should be removed or the addition made or fails to respond. So if we offer an interview to an individual and there's a alleged perpetrator and they choose not to respond to us, then that should not hold up our pursuit of a substantiation. So the rest of the details you could see in the memo. If you have any questions for me, I'd be happy to try to address them.
And this is helpful. So, and as we go through the bill, we'll come back to your recommendations and look at the broader context.
Sure.
Thank you. This is a big bill, and I know how hard people have worked on it, and our time has been cut short by the fire alarm, but that doesn't mean we won't be coming back to it. And I know there will be continuing discussions and concerns about everything that is before us, including your comment on the negligence piece or neglect or however that is as compared with professional standards. I think we'll look at that. but we need to hear testimony. So this is a wrap. We'll come back, we'll put this up on, and with all due respect to folks who have made it here and traveled here and are here to testify, if you have written testimony that you could share with us, and we will invite you back in, whether on screen or in person. I'm looking at you, Ruby. Thanks for being here. So we'll come back to the bill, because we do know how important this is. And Alex, that's a wrap.